Hey guys, it's Kathy. I hope you're doing well. And if you are in the path of a hurricane, you don't really have to be online right now. You could just be doing something really safe. Like, shouldn't you be in a doorway or underground somewhere right now? I know what you're gonna say. It's not a tornado, not an earthquake, but it's a hurricane, so it's something. There should be something you should do. I remember we got a hurricane back in 2002 or 2003 or 2001. No, it wasn't 2001. It was either 2 or 3 or 4 in Pennsylvania here. And, like, we just it was more fascinating than scary to us. Like, it was just a lot of wind and rain. So we're used to blizzards, which, is wind and snow. So, the whole time the hurricane's going on, everybody said the same thing. "Whew, at least it's not snow. At least it's not snow." But no, we don't have to deal with hurricanes. But you guys are it's very scary thinking of you guys in the middle of a hurricane. I mean, where do you go? Do you go, like, to your basement? Do you have basements? It's not a stupid question. They don't have basements in Florida. Do they have basements in Texas? I don't know. I have no idea. Basements are in every single house here. Nope, no basements in Texas. Right. All the Texans are horrified that I said basement. Mm. Gotcha. So, remember I said Egypt, and then I told you yesterday someone was from Egypt? Another one was from Egypt. They're in Wisconsin right now, or Minnesota, but I think it's Wisconsin. And then they're going right back to Egypt. Isn't that cool? In all of Australia or just where you are? Yeah, because my son lives in the basement. He's he's so loud, guys. You don't understand. He's playing those video games and he's so loud. So we threw him way in the basement. If I could build a second basement under that basement, I would. Wow, basements aren't a thing. And so, what about your attic space in Australia? Is that usable or is it just, not usable? Because if you don't have a basement, in Pennsylvania, we have a basement and an attic and our floors. So, like, we have a house, but we have spaces, lots of spaces in that house. Dungeon. Yeah, the attic is the basement. I get it. No way. Guys. Oh, yeah, you're the one are you in Wisconsin? You're the one that said that, right? That you're in Wisconsin? Or was it Minnesota? Why do I get those 2 mixed up? They're 2 completely different states. Interesting. So you guys just, like, have 2 floors and that's it? You don't keep all your Christmas stuff up there and your Easter stuff and clothes from the '70s and your spare rib bassinet that you're never gonna use again because, you can't have kids anymore. A lot of our attics are built such that if you step in the wrong spot, you'll fall right through because it's just a piece of drywall separating you from the floor below. You have to stay in the right spots. You're in Malaysia. So, not many basements in Malaysia unless it's a commercial building for a parking lot. I translated it for us. Although we have a lot of Australians and UK people here saying parking lot. Car park was right. Mm. Yeah, always walk on the cross beams unless someone is recording. One floor, that would be, I don't know what I would do. I have so much stuff. What does hunker down mean though? I get it. Hunker down. That's the thing everybody says. But how do you hunker down? You just sit there? I hope everybody in Texas is okay. This is horrible. I don't like this at all. No. Well, okay. So you know how I said that I okay, drink beer. I that's the hunkering down that I can do. I can drink beer and, hope. That's what I do for all other fires that are going on in my life. I just drink a beer and hope. Mm. I don't know. If you had a basement and an attic and a double garage, you would, after like 6 months, think that you couldn't live without them. Or gin. Slow gin fizz. I love those. So that's what we need, but they don't have a basement. So how are they going to get a room with no windows? I don't know. Is it? That's what I'm wondering. We have blizzards. We have lots and lots and lots of snow here. So that's, we just need salt and a shovel. That's how we prepare, salt and a shovel. Your house might just like, okay, I don't want to talk about that. Bathrooms have windows. All bathrooms have windows. Your bathrooms don't have windows. That way, if it scares the poop out of you, you're in the right spot already. But your bathrooms really don't have windows? It would be so dark. I mean, I turn the light on, I get it, but okay, I do have one bathroom here without a window. However, it didn't come with the house. One day my mom just decided to put a bathroom in the dining room. Yep, in the dining room. Yes, in the dining room right beside the kitchen. And it's only like this big. You could just there's no sink in there because there's no room. So, what does it say, Eileen? When you go to that link that I gave you, this link right here, what does it say? Is that the right link? I thought it was you used something. Hold on. Ah, I closed Discord. This isn't going to last long. So use this link right now, if possible. I have to close Discord again or it'll keep dinging while I'm trying to do my live. Try that one. While you do that, we are going to go to okay. Roommate. Nope, let's do $50. We'll do $50. We'll start nice and easy.
Bill's ready. Okay.
How you doing, Judge?
I'm doing all right. So tell the jailer that you want to go into the breakout room.
You said what?
Tell the jailer that you want to go to the breakout room.
The jailer, I want to go to the breakout. Okay.
That's pretty simple. So what's the deal?
Judge, he's willing to plead guilty to the no insurance charge, and he would like to be able to get it set up on payments. He says he can do $20 to $40 a month if the court's willing to do that.
We usually do about $50 a month, Mr. Hill. Can you swing that?
I can swing that. I
All
can
right.
cut another yard. I can cut an extra yard to get you your extra 25. I don't care.
Well, heck, talk to Mr. Probst. He needs someone to cut his yard.
If he do, I can cut his yard.
All right. I'll go ahead and accept the plea agreement, plead guilty to trespassing.
I
No
appreciate you, boss.
insurance, excuse me. And we'll set
Right.
your first payment deadline of August the
11,
6th. August 6th.
6 is cool.
All right. So anytime between now and August the 6th, if
Okay.
you make a payment of $50 or more, the clerk is going to give you an additional 4 weeks to come up with another $50 payment.
Yeah, I
You
like
keep doing
that.
that. You don't have to show up in court.
I like that.
All right. So
I'm free to go.
yeah, I see that you've been released on everything else. Looks like you have a. Let me check something out here. Looks like you picked up a new possession of marijuana, so I don't see that that's part of the plea agreement. So when you get that ticket, you'll have to come to court on that date, regardless. Okay?
All right, but I can go home today.
Yes, you can, unless you have
Thank
a
you,
hold
boss.
from someplace else.
No holds.
All right, sounds good.
Thank you, boss.
Yep.
You have a wonderful day.
You do likewise.
Okay. Spade made me go watch Reagan today. And I really thought I got this clip and it's just gone. Hold on, I'm going to open up a clip and hopefully this is it.
You just grab that seat right there
Nope,
and you can have a
it's
more
just
comfortable seat while
absolutely not it. I know that I got it ready for today, but it's not here. So I'm just going to keep going with the clips that I do have. So next we're going to go to roommates that have Bible verses and cardboard that cause all kinds of issues. It's like spaghetti, guys, again. And it keeps twisting and turning.
And Edna Squally, what's your name?
Miguel Ramos. Can you hear me okay?
I can hear you just fine. It can take me a minute to call your case, though. Mr. Swenson, you're here with Mr. Ramos?
Sorry, Your Honor. I was unable to speak with Mr. Ramos. If I could have a breakout room with him.
You can.
Thank
You
you.
can go ahead and put him in a breakout room. Ms. Pasquale again, with the beard and the orange.
Yes, Miguel Ramos.
Mr. Swenson, you had a chance to speak with Mr. Ramos?
Yes, Your Honor, I did. I went over the nature of the charge and Mr. Ramos's constitutional rights, which I believe he understands. There's no stipulation to probable cause today, so the city will need to establish. I have a probable cause argument if the court's willing to hear it.
Mr. McClellan, raise your right hand, please. Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Go ahead.
So the allegation is harassment, domestic violence. This is between roommates. The police report from Officer Byer notes that on the 3rd of July, 2024, around just before midnight, dispatched to a domestic violence incident at 4812 50th Avenue. It's in Lacey, Washington. The call notes that 2 roommates were harassing the reporting party and making threats to whoop his ass. The officer made contact with the reporting party, Travis Wilbur, who stated his roommates had put a piece of cardboard in the refrigerator and he threw it away in the garbage. He said that this made his roommates angry, and as a result, his roommates began screaming at him and pounding on his bedroom door and making threats to, again, quote, beat his ass. Travis stated he felt unsafe in the home and believed his roommates would carry out the threats. And Officer McBride identified the roommates, one as Ryan Miguel Ramos and the others to Tanaya Trusty, who will also be on this afternoon. I confirmed their identity with driver's
Who's
license.
the other one?
Tanaya Trusty, last name Trusty.
Got it.
So Officer McBride advised Officer Byer that he also spoke with another roommate, Leopoldo Schwartz, who witnessed the roommates threaten Travis and heard them threaten to, quote, beat his ass. Schwartz did not provide a written statement because he was leaving the location. And based on what the reporting party stated, as well as the roommate that witnessed it, the officer arrested both Mr. Ramos and Ms. Trusty. He did speak with Ms. Trusty outside of the residence, and she said she was mad at Travis for destroying the cardboard, but she never threatened him. And she actually said that God would beat his ass. And based on the statements of the alleged victim as well as the roommate, it does generally refer to both.
Good luck in your meeting.
roommates as making these threats or threatening behavior. But that's the information in the police report that the city is relying on for these charges.
Mr. Swenson?
Thank you, Your Honor. I understand probable cause is a very low standard, but I believe the allegations here lack the specificity required to find probable cause for Mr. Ramos. Not only are the alleged statements or threats vague, but who made those statements specifically is not referred to. It seems like the police report, the officer, and the reporting party all lump both co-defendants together in making these statements. I don't think it's clear. I don't believe there's enough information to state what statement was made by who.
Based on, again, this is a preliminary stage in terms of probable cause. Based on the recitation of facts from Mr. McClellan, I will find probable cause for one count of harassment.
Our first Texan just went down, guys. They're going down. They're crashing and burning. They lost power. No. We have to help. We have to do something. We need a really, really, really long extension cord, please. Oh gosh. Sugarland is you, Irish Dublin, right? You're in Sugarland. Go to Fozzie's house. 30 minutes away. Go to Fozzie's house. Go drink his beer. He would be so thankful. Oh.
Discuss with him his legal rights there, Mr. Swenson. Do you wish to have me advise him formally?
No, I discussed his rights, and I believe he understands them. We will enter a plea of not guilty today with that finding of probable cause, and he is seeking court-appointed counsel based on the information he provided. I believe he would qualify, Your Honor.
I'll appoint Pacific Point Law Group to represent him. Mr. McClellan, I'll hear from you on conditions of release.
Thank you, Your Honor. The city is not asking that Mr. Ramos be held on any bail. No objection to his release. With conditions the city would recommend and request would be to not have any criminal law violations, not possess a dangerous weapon or firearm. And the city is asking for a no contact order, a pretrial no contact order this time. The only other information I have from the alleged victim through the advocate is just that he does have concerns for his safety. He indicates that there's been escalating behaviors towards him over this last week. And so these threats that he took serious do give him concern. So I'm asking for a no contact order. I know it's a complicated scenario with being roommates, but I no objection to a civil standby if the court does enter the no contact order.
I don't see a no contact order prepared.
Let me see if it's still,
I see there is one for trustee.
okay, I'm moving it over to your.
Mr. Swenson, what's your position on conditions of release?
Your Honor, I would object to entry of the full no contact order at this time. It's going to be extremely restrictive. It essentially will render Mr. Ramos homeless at this time. He has no criminal history, Your Honor. I don't know. This is the first time I'm hearing about any allegations of prior instances or escalating behavior, but I think that there would be least restrictive measures for the court to take, including no hostile conduct. Thank you.
Just a second.
May I speak to the attorney real fast? Is that possible?
To your attorney?
Yes.
Yes, you can. Want to go back into a breakout room there, Mr. Swenson?
That's fine, Your Honor.
Sure. What case are you here for? Ritter. Ms. Moore,
Yes.
could you see if Mr. Ritter, Jasper Ritter, is still there? His attorney's here in court now.
Absolutely, Your Honor.
Mr. Ramos
Yes, sir.
and Mr. Swenson, I'll come back from you. Anything else you want me to know about all this?
Yes, Your Honor. So Mr. Ramos indicates that the shared living space is actually different levels. He and the co-defendant live upstairs, and the protected or the alleged victim lives downstairs. They do share a kitchen and a laundry room, but Mr. Ramos has indicated that he would be able to avoid any shared living spaces if the court were to tailor the order to allow him to at least return to his room upstairs. So that would be defense's request, given the unique situation. It is a roommate situation, and like I said, if he's not able to return home to sleep there, he'd be rendered homeless, and he is working at Amazon and likely lose his job as well, Your Honor.
He's working where?
At Amazon.
Judge Fleischer would
How
be
long
so
has he lived in
proud.
this house?
I'm not sure.
I'm coming up on 3 months.
How long has the other person been living in the house?
Hi, girly girl.
I do
I'm
not.
asking anyone, you don't need to answer that, Mr. Not really talking to you right now, but although I might be in a second, if no one else can provide that information.
The other person, meaning the protected party? I mean,
Yes.
the alleged victim? I don't know.
Yeah, I'll see if there's any. I don't know either, Your Honor.
Well, do you mind if I ask your client there, Mr. Swenson, whether he was there when he's been there for 3 months? Was the protected party there when he got there?
You can ask. You can answer, Mr. Ramos.
Yes, Your Honor.
So he has been there longer than you have. Mr. McClellan, what's the city's position?
Yeah, well, yeah, I don't know the layout. I mean, I don't have any reason to
Don't worry, guys. The judge tries to get to the bottom of this. He tries to get to the bottom of the issues.
dispute what Mr. Ramos has expressed as the layout. And again, and Mr. Swenson is correct. I don't see criminal history, and the only information from the protected party was I don't have specific allegations of what happened before. Just there's been escalation that why he's fearful, concerned about being in the same place. So he supports the no contact order, and so the city, under the circumstances, is requesting that. But if there was a safe way to have an exception, I can respect that. I just don't know how that works in the same actual residence. I think that's a little more complicated than just if they were neighbors. Given their shared living space, I think that doesn't necessarily alleviate the safety concerns.
What sort of living space is this? Is this like a house or what exactly?
Sounds like a 3-level house. And I didn't speak with Mr. Ramos very long, but he indicates that he lives in a bedroom upstairs, that there's the alleged victim lives in, I guess, the lower level basement, and then the middle level is the kitchen. Is that correct, Mr. Ramos?
No, the upper level has the kitchen.
Okay.
The middle level is just like the entrance at the foyer, and then downstairs is the shared laundry room.
So the upper level, all roommates have access to the upper level.
Yes.
Okay. I've never seen a situation like this, Your Honor. It's a complicated one. I would just.
Well, that's not what I'm hesitating. I'm almost scared to ask this or mention this, but this is all over a piece of cardboard left in the refrigerator?
Yes, it is.
So
that's the unusual part.
Right. So Mr. Ramos has shared additional information with me. Obviously, the police report doesn't mention what was written on the cardboard or any specifics about that. I think that is going to be relevant.
Well, then tell me about it.
Well, the cardboard, I'm told, Your Honor, specifically had a Bible verse on it, which would tend to, if we could have that cardboard or pictures were taken of that cardboard, I think that would tend to confirm or corroborate what the co-defendants had said, because there is a dispute over what was actually stated here, which I think is going to be relevant moving forward.
Okay. So, Mr. McClellan, can you provide any insight as to what was alleged was put on the cardboard?
So the other co-defendant, when the officer spoke with her outside the residence, she stated Travis is dirty, which is why they wrote a note on the cardboard for him to see. And she said that she was mad at Travis for destroying the cardboard.
It was about an extended warranty.
She never threatened him, but that's, I guess, where the reference is. She said God would beat his ass.
Right.
And so when the
And
officer
was there something on the, okay, I apologize for interrupting, but was there something on the cardboard that was a comment on the protected parties? I don't know what the right word is there.
So, I mean, I'm looking at
dirty. Someone was dirty.
I don't share drinks.
Not a lot of elaboration on that, or any, I should say. The officer noted that they observed the cardboard on the kitchen counter and it did not appear to be of any monetary value, and said it was merely a piece of cardboard with a note written on it. I don't have photos of that right now, or no. They didn't. The report doesn't reflect what was written, but that's all comes down to what Your Honor already was highlighting, that this seemed to be over.
Well, yeah. So, I mean, it wasn't the cardboard. It was what was written on the cardboard. So, Mr. Swenson, Mr. Ramos is wanting to tell me something. Is it all right with you if he does?
Well, I would advise him not, Your Honor. I think he wants to get into the facts of what was written. So, Mr. Ramos, I would just, if you want to address the judge, I would just be careful, and anything you say can be used against you. But that's your.
Can I speak to you? Can I speak to my attorney again? I apologize. We didn't have time to talk.
You can go back and speak to your attorney. You could come on up, Mr. Jaspers, Mr. Ritter. Jaspers is first name. Okay, Mr.
We will find out.
The breakout room here, Mr. Swenson. So,
just a couple of additional things to add, Your Honor. Mr. Ramos did give me the specific Bible verse that was written on the cardboard. I don't know if Your Honor cares to get more context to that.
I do, because I think it might provide some.
Okay. Well, it was Ezekiel 44:23. And I just a quick Google search, Your Honor. I'm not familiar with the Bible, but it does reference being unclean. What I wanted to also mention, Your Honor, is Mr. Ramos has indicated that he had attempted to address the uncleanliness with the alleged victim in other ways through text before putting the cardboard in the fridge. So I think that's the ultimate issue. It's cleanliness of the shared spaces.
Yeah, that can be taken any number of ways. And so what's going to happen today is he's going to be released on his personal recognizance. Conditions of his continued release are don't have any criminal law violations, don't possess a firearm or other deadly weapon. We're going to set a court hearing for, it's a Pacific Point case. August 13th at 10 a.m. for pretrial. And for right now, Mr. Ramos, I am
Thank
going to
you
sign
so
a no
much.
contact order.
Thank
You're
you.
not to have any contact with Mr. Wilbur. No contact means no calling, no texting, no emailing, no leaving cardboard in the refrigerator.
Maybe
There's going to
that's
be a
it. I don't
1,000-foot
know.
distance restriction. So for the time being, for the immediate future, you're going to have to find some alternative living spaces.
I mean, it sounds like a threat. It does. Its heavy rust cannot be removed even in fire. By your sinful actions, you have become unclean. I wanted to cleanse you, but you are still unclean. You will never be cleansed from your sin until my anger against you is carried out. That sounds like a threat, doesn't it?
And
Oh,
Refuse the shared
that was unfortunate.
laundry.
So the upper level.
Do I need to go forward more? I can't remember where I was.
Access to the upper level.
Yes.
Okay.
I think I do, don't I?
I don't know what the right word is there.
So, I mean, I'm looking
The
at
dirty, someone was dirty. What was that all about?
not a lot of elaboration on that, or any, I should say. The
Hey, Brad.
officer noted that they observed
I have
the
to go
cardboard on the
forward
kitchen
more.
counter
Hold
and
on.
did
I
not
don't
appear to
remember
be
where I
any
was.
Reference being unclean.
There.
What I
Good
wanted
enough.
to also mention, Your Honor, is Mr. Ramos has indicated that he had attempted to address
Jackie.
the uncleanliness with the alleged victim in other ways through text before putting the cardboard in the fridge. So I think that's the ultimate issue. It's cleanliness of the shared spaces.
Yeah, that can be taken any number of ways. And so what's going to happen today is he's going to be released on his personal recognizance. Conditions of his continued release are don't have any criminal law violations, don't possess a firearm or other deadly weapon. We're going to set a court hearing for, it's a Pacific Point case. August 13th at 10 a.m. for pretrial. And for right now, Mr. Ramos, I am going to sign a no contact order, and you're not to have any contact.
Just remember, guys, he's the clean one. He wanted to beat the ass of the unclean one. Him and his co-defendant. There's two of them. He's the one that wrote on the cardboard, or she did. One of these two wrote on the cardboard for the other person that we don't see that's the dirty person. I got confused too.
With Mr. Wilbur. No contact means no calling, no texting, no emailing, no leaving cardboard in the refrigerator. There's distance restriction. So for the time being, for the immediate future, you're going to have to find some alternative living spaces. And that's what's going to happen here today. that does a one-time civil standby. You can go one time with law enforcement for the purpose of obtaining personal items from the establishment on 50th Avenue Southeast. You can work with your attorney. You can work with the victim's advocate, and so some sort of arrangement or agreement can be worked out to readdress this no contact order. That can happen, but that's where we're going to start. I don't think I may be putting a lot more significance into that sort of behavior, leaving biblical verses directed, unkind biblical verses directed at a different person. Not a real big fan of that. And I don't think Mr. Wilbur was either, which is why he did what he did. And so that's how we're going to start. And your next court date is going to be August 13th, as I said, at 10 a.m.
He can use the cardboard as the start to a new house.
You'll get released here later today.
Because
you're going to get contact in.
We just found out you don't really need an attic or a basement. You'll be fine. Okay, guys, don't worry, because I have got the defendant, the other defendant, the co-defendant. But this is way shorter. The judge already went through all the craziness. He doesn't go through all the craziness again. He just ends it right quick. Hi, Lori.
She's the co-defendant for the Ramos case, Your Honor.
Yep, I remember.
They don't have the cardboard anymore.
So, you're today a trustee. You're charged with one count of harassment. And Mr. Swenson, earlier you objected to a finding of probable cause. I have reviewed. Are you renewing your objection? I think I can rule on what I've heard thus far, but you can certainly object again.
I would object just based on the same grounds as the Ramos case.
And so I've previously heard a fair amount about this case already. Based on what was recited earlier in the calendar, I will find probable cause for one count of harassment. That's a gross misdemeanor, ma'am. The plea of not guilty will be entered. This matter will get set for future hearing. We're going to set conditions of release. I'm going to hear from the city of Lacey on conditions, and then I'll hear from Mr. Swenson.
I think it was his anyway.
On the other one, was that Pacific Point or was that Ms. Langley, Mr. Swenson?
Pacific Point. So Ms. Langley will need to be appointed to.
Yes, I'll appoint Ms. Langley on Ms. Trustee. And Mr. McClellan, I'll hear from you.
Thank you. It is a similar request from the recommendations on Mr. Ramos's case. No objection to Ms. Trustee being released. And I know it's an unfortunate dynamic here under the circumstances, but given what's alleged and the concerns that the reporting party does have at this time, the city is also asking for a no contact order, at least for this at this time. No weapons, no criminal law violations.
Mr. Swenson.
Like before, Your Honor, I simply object to entry of the no contact order. Request the same exception to be made for Ms. Trustee to be able to return to the house and live upstairs. I did discuss it with her, and I understand Your Honor's ruling in the other case, so expect it to be the same, but I would make that objection for the record.
Me too.
So, ma'am, you're going to be released on your personal recognizance. Conditions of your continued release are you're not to have any criminal law violations. You're not to possess a firearm or other deadly weapon. I'm signing a no contact order that you're not to have any contact with Travis Wilbur. Do you understand that? There's also a distance restriction in here. You're not to come within 1,000 feet of his residence, workplace, or any other place he's located, which means you're probably going to have to find a different, for the immediate future, different living arrangements. This does provide for a civil standby. For a one-time civil standby, you can go by with law enforcement to pick up personal belongings, but that's it for now. Do you understand that, ma'am? Your next court date is, just a second. August 12th. Did you say 10:30? at 8:30. You have a cell phone where we could send text reminders to? What is that?
She has a hard time answering this question.
Eight five five. That'll be it for today, ma'am. We'll see you back here on August 12th at 8:30.
I agree, but I'm glad it happened because I really never experienced that kind. We've never had that before. All right. What did I do so far? I don't even know what this is. It's a 2-minute clip. Listen, guys, this could be something or nothing. I don't know why I have it here. I wasn't even drinking today. Oh, yeah, I was, but I was at work.
13087A. She is. Yeah, that's right. Appearances for the record.
Ethan Day on behalf of Mr. Marr, Your Honor, we'd waive the formal reading.
All right. Let's see. Bench warrant, failed to respond to a 10-day letter. How long has he been in jail?
Mr. Marr,
Overnight?
how long you been in custody for, Mr. Marr?
Maybe 9 hours.
Yeah, whatever. You owe, $225 to Judge Clark on that misdemeanor. Why aren't you taking care of it?
I did not get any mail at my address. I don't have a mailbox. I have a PO box.
Why do you just ignore the courts? Come on.
Well, huh?
What have you done to get your license?
Oh, I tried to go fill out a packet and I tried to give it back to the judge, but he told me that I was playing around, which I wasn't. I was filling out the packet.
You're wasting air in jail. You know a judge doesn't issue a license? The Secretary of State. Your driving record is enough that you should have had enough contact with
The judge told me
it's the Secretary of State that does all that. Recall based. What are you gonna pay it?
Judge Mr. Marr informed me that he could pay everything when he gets paid at Hooters. He's been there for a long time. He's been there full time. He can pay everything on Monday.
He works at Hooters.
All right. Well, your civil infractions, since you've been in custody, those were credited time served, okay? Suspended it since you got to smell the wonderful inside of that jail. Now, on the misdemeanor ones, you're gonna have to pay that. So time to pay will be 1 week. You gonna take care of it?
Of course.
All right. Just put your license so you don't run into local law enforcement. So have a good day. Be well.
Thank you, Judge.
2438.
So was the smell of the jail enough to let you know that you need to pay this? I love that. I even named this clip "Smell Jail." Now I know why. I couldn't remember that. I like that, Judge. Okay, guys. All right. I started to tell you earlier. Are you ready for this? Okay. So, remember I said I was going to ration out Judge Fleischer so we had enough for every day? Well, I didn't. So we ran out. I was looking through this whole week today, and we saw it all. We saw it. So we ran out of Judge Fleischer because he took that day, 1 day off. And he's off today too. So I won't have any for tomorrow either. And I can't, but I found a new judge, but I don't know if he's a new judge. Okay. I don't know if you guys have seen him before. Yeah. Courts are closed today. He's in DeKalb County and he's fantastic. He's so good. He has saying after saying after saying after saying, but unfortunately, Judge Fleischer doesn't have a Texas accent. You all know what I mean, like the real Southern Texas accent. But this guy does. This guy, he doesn't have a Texas accent. He has a Southern accent. I don't know, probably Georgia. I mean, that would make sense. But I went to look him up after I got this clip, and I'm like, oh man, when can I see him again? Where can I see this guy again? He retired in 2020. I think he's just filling in, and it's gonna break your heart because it's so good. I don't remember any of the cases. I just remember the judge. So, and I only got 25 minutes of him. And this is the last clip for today, guys. 25 minutes. But it's really good. It's like it's child support and parenting. It's one of those courts. But he's really good. Are you ready? Are you ready? Are you ready? I am.
I think that's right, isn't
It's twice, sir.
it? Hey, I'm sorry, you corrected me twice. I appreciate that, and I apologize for. Let's see. Let me see where we are.
Judge, if she's not here, it's her contempt, so you can dismiss it.
I will, but I'm gonna give him about 10 minutes. All right.
Okay.
Mr. Twaits, if you'll hang on for about 10 minutes, if she doesn't appear, then you'll make a motion for me to dismiss it, and we see how that goes. All right.
Yes, sir.
All right. Thank you. All right. James Green versus April Harden. I think both parties were here. This is the final hearing, I believe. So let's see. The moving party, I guess, is Mr. Green.
Yes, sir.
All right. Tell me what's going on.
Well, we had a temporary order in place where for the months of March, April, and May, I was on I guess a trial period as far as patient with my daughter, and went well. And so I'm moving to finalize an order. I'm also moving to have a meeting point. I live in Columbia, South Carolina, and my daughter lives in Atlanta, Georgia. The meeting point has
I love that color. I love it.
As the exit, but I'm willing to go as far as 165 if that cuts down on travel time for the mother.
Okay. All right. And I think there's a child support order out of Lexington County. Is that right?
Yes, ma'am. Yes, sir. I'm sorry. Yes, sir.
So we're only dealing with the issue of visitation and scheduling a meeting points. What my understanding is. That right with you?
Yes, sir.
All right, Ms. Harden, what do you say to that?
Yes, he and I, we've spoken on that, and yes, we have made an agreement. As far as the meeting point, I did let him know that when I'm available, if it's not due to work or anything like that, then I will meet him at a meeting point.
All right.
So as far as
all right, did y'all agree on a schedule, or do you want me to put a schedule in place?
Well,
I'm gonna let you go ahead. I'm gonna let Ms. Harden talk first on this one, then I'll come back to you, Mr. Green.
All right.
So I think the arrangement that we created on our own has been working. Do you agree, James?
Yes. It has been.
That's refreshing.
I want to see how the school year, as far as once a month.
I need a little help now. When I don't know what y'all's agreement is, tell me what y'all's agreement is. Is it every other weekend? Is it one weekend a month? Or
Charles?
Is it the school holidays? I think your daughter's 12. How old is she?
Yes, sir. She's 12.
Okay, and so she'll be going into the 6th or 7th grade?
7th, yes, sir.
Okay, all right. So was this y'all's agreement once a month, every other weekend? How was y'all's agreements get planned out?
It was scheduled for once a month. And as far as like holidays, we were going to work that out between us. Summer months, we didn't really get to discuss that. I was hoping to maybe get her a month after summer.
He gets better. He gets so much better.
Summer said, when school gets out, you get 2 weeks, and then she gets 2 weeks, and then you get 2 more after that. So you end up with 4 weeks, but it's not. It's 2 a break and then 2 more. That's what my summers usually do, because children only have that 8 weeks of summer versus when I was a child, we got 3 full months. All right. Yeah, y'all, that's what happens when you get to be old. You had 3 full months, but we did not have fall break. You had the day before, you had the Good Friday, and then a couple of weeks of Christmas. But other than that, you were in school and getting paddled. Well, I was, not everybody is. Okay, so why don't we do this? I'm gonna. Do y'all have a particular weekend each month that y'all had scheduled, or what?
It's usually every 4th weekend. Like, so for instance, I have Jada now. So I'm actually bringing her back to Atlanta today.
Okay.
So as far as August, because in a week I'm leaving to go to military training.
Where you going?
Columbia. I'm staying in Columbia, but we do our annual training. We do different locations each summer. So
are you in the reserves or National Guard?
National Guard.
Okay. All right. So why don't we do this? If it's been the 4th weekend of each month, I'm going to put it in that 4th weekend of each month, but y'all may alter it should you agree. I'm going to give you each 4 weeks in the summer, 2 and 2. I'm going to put in there you alternate national holidays, but because y'all appear to be communicating like adults and seem to be able to resolve in this matter, because the daughter's old enough that she recognized what's going on between the two of y'all, so y'all apparently on your best behavior, and that works really well. So I will put a basic order in place, but it's the floor. All right. If y'all want to do something otherwise, you certainly are capable because you're adults. But the minimum is you get 1 weekend a month, you get basically half the summer, and you alternate national holidays. Now, historically, some people have celebrated Christmas a day or two before, a day or two after, but I like to split Christmas. From Christmas, one person gets from schools out till Christmas Day at 2, the other gets Christmas Day at 2 until New Year's Day at 2, and then the next year will be the other way around. That's up to y'all, but I'll put the same as whomever gets Santa Claus, because I believe in Santa Claus, whoever gets Christmas Eve with Santa Claus, then doesn't get Thanksgiving that year, goes to the other year, all right? So if you have her with you for Thanksgiving, then you'll pick her up at 2 o'clock on Christmas Day, and then the other next year it'd be just the opposite. You won't have Thanksgiving week, but you'll have school out until Christmas Day at 2. That way everybody gets to share in the excitement and disappointment about what children get on Christmas Day. So, all right. Anything else I need to put in this order? Do I need to put in the order the location for y'all for the exit number, or do y'all, sometimes the government changes the numbers. I don't think they will from here on out, but you agreeing to me?
The location for y'all, the judge just said that. He's a sitting judge. The location for y'all?
The exit 162.
Well,
I can't wholeheartedly agree to that meeting point. I can meet him. I just have to calculate it myself. I can't say I can meet him at that particular meeting point. And then
Y'all have
also, I have a very... Sorry, go ahead.
Yeah, I'm sorry.
No, I was going to say I also have a late schedule. I'm only off on Saturdays and Sundays, so I know he usually tries to pick her up on Fridays. I don't get off until like 6:30 in the evenings.
Man,
so that's what I'm trying.
I'm not going to put a time frame, but I think it ought to be on Friday evening, and it could be a little bit later. Y'all can pick the spot. All right. So the weekend begins to me on Friday. Well, people I've worked with sometimes think it begins Thursday afternoon. Don't want to, not this group, but I'm gonna say Friday to Sunday, unless y'all agree otherwise. 1 weekend a month.
Well,
what do you say to
that works out because I actually picked my son up from Lancaster, South Carolina. So the fact that she gets off at 6:30 actually gives me enough time to get down there.
All right. Okay. All right. Then y'all each have what they call cell phones, don't you?
Yes, sir.
Yeah, I mean, all right, good. Well, then apparently those things operate across state lines, so y'all can communicate on the time and the locations, but it's going to be the fourth weekend of every month. Yeah, we'll split the summertime, we'll split national holidays, and then y'all can expand them if y'all agree. You know, really, you should have this order, then you should stick it in a file and never have to look at it again because y'all are able to communicate appropriately. All right. Anything else I need to hear from either one of y'all?
Well, this is for Ms. Harden. Now 160, it adds 30 minutes to mine, but I can go as far as 160 if that be a base.
I'm going to make a conscious effort to just like really look at the location because I haven't done it, and I've talked to you about that. I've said what I've said. So, but I am going to make the conscious thought to actually look at it and like really try to find a meeting point. I'll work with you.
Okay, good. And let me be honest with y'all. I'm not a preacher. All right. I'm not here to give forgiveness to everybody.
Yes, you are, though, aren't
Y'all
you?
work it out. If you don't, then I'll do what the court has to do. All right. I'm excited for y'all. This sounds like it's working. Remember the key.
I'm not a preacher. Yes, he is. Yes, he is.
To successful parenting between two parties that are not together is the ability for each of you to bite your tongue and not say everything that comes to mind. Okay?
Yes, sir.
There you go. All right. I'll get y'all in order. I wish you the best of luck and have a great weekend.
All right. Thank you. Likewise.
Thank you.
Bye.
Bye-bye. All right. Next, we have Dalton Skaggs and Caroline Ross.
Yes, sir.
Present.
All right. Is Mr. Skaggs here?
Yes, sir.
All right. And Ms. Ross?
Present.
Okay. Okay. Y'all tell me what's going on. I will start. Looks like Mr. Skaggs, you're the moving party. Tell me what's going on, and I'll hear from Ms. Ross.
Yes, sir. I filed a petition for divorce for Ms. Ross on January 4th, and we haven't come to a settlement agreement, and I believe that's why we're here.
Okay. All right. Now, it's my understanding y'all have no children. Is that correct?
Correct, sir.
All right. My understanding, y'all don't have to joint property to divide. Is that correct?
Yes, sir.
Okay. Well, then I'm confused in why you're here. If you have no children and you don't have any property to divide, what would be an issue remaining from either one of y'all?
Am I allowed to?
You may speak, and then I'll
Okay.
come back to Skaggs. All right. Yes, ma'am.
Yes. So Dalton sent me a settlement agreement and I signed it this morning.
Okay. All right. Have you gotten it back, Mr. Skaggs?
He answered my email.
I received a settlement agreement that I sent Ms. Ross months ago, and she finally
I'm
signed
not
it.
worried about when you sent it. Look, I sent my taxes in the other day. I have to pay the price. Would y'all both do me a favor because I've just gotten chastised? Would y'all both raise your right hand? Do you swear a firm testimony about to give the matter opinion before the court shall be the truth, the whole truth, and nothing but the truth that you got?
Yes, sir.
Yes. So you now have a settlement agreement that was been signed by Mrs. Ross, although if it were a library book, she'd have to pay a lot of money in fines, right?
It's been initialed by Ms. Ross, not signed. Yes, sir.
Okay, all right. And let me ask you this. Tell me the date y'all were married.
June 10th, 2023.
And when did y'all separate?
I believe it was November 6th, 2023.
Okay, and since that date, have y'all...
December 17th.
All right, but let me ask you this. Y'all both been separated for at least 30 days. Is that correct?
No tax refund.
All right.
It's just
And
a
Mr.
divorce.
Skaggs, you've alleged the marriage is irretrievably broken. Is there any hope of y'all going back together?
No, sir.
Okay, then I'll grant you a divorce. If you want to sign that agreement and send it into the court, we'll do that. And I presume that since there's no property to divide, then what we want to do from here on out is simply live well. If you want revenge on the other party, you just live well and move on, okay?
Yes, sir.
You'll
Thank you,
submit
Your
that. and you'll submit that document to the court. We'll attach it to the final divorce decree. Ma'am, you initialed it, is that correct?
Correct. It didn't sign because there's no notary, and that's actually a question I had if we e-file it or bring it down to the courthouse.
Well, I'll ask Ms. Simmons that. Ms. Simmons, can they just e-file it?
It's fine. They've said on the record that they agreed to it. If Mr. Skaggs, if you could actually e-file it once you sign it. And if you have any issues e-filing it, just just contact our staff.
Okay, and then I do have one question.
Sure.
With the document, should I have Ms. Ross sign it and then send me the document so I can initial and sign and then e-file it?
Y'all don't have to. We've got on the record that y'all agreed to this settlement agreement. Yeah. So you can just sign it. You don't even have to get it notarized and just e-file it. It just needs to be on the court file, and the judge will do an order that incorporates it.
Yes, ma'am. I guess just my question. I apologize. Okay. I guess my question was just, does Ms. Ross only initial and not sign? Do we have to get her to sign it?
She's admitted. I don't think you need to worry about getting her to sign it. I just don't want anybody to change it and say one person owes the other one $1 million, which quite frankly has happened before with me. It wasn't $1 million, but it was a lot of money. So y'all agreed to it. I appreciate it. I wish y'all the best of luck, both of y'all. Thank y'all.
Thank you, sir.
Okay. Next we have
that was the only clip I was going to get, but I'm just going to keep it going for the next 10 minutes because I love this judge.
Aquarius Flint versus Desiree Hunter, and if I mispronounce it, I apologize. Is Mr. Flint here? Okay, I think you need to unmute yourself.
Yes.
Okay, and is Ms. Hunter here? Okay, make sure you're unmuted. Okay, this is the petition for legitimation. Is there any objection to the legitimation, Ms. Hunter?
No.
Okay, all right. Didn't file a response. And how old is Destin?
8 years old.
Okay. Now, has his father participated in his life up to this point?
Yes.
Okay. So his father should have visitation with his son. Does he get visitation?
Yes.
Okay. How often is that? Do you know?
We do every other weekend.
Okay.
And
all right. Perfect. So what we consider some kind of a traditional visitation schedule?
Well, we agreed to every other week.
Every other week?
I didn't. Yes. Well, I didn't. I just said it would interfere with his schooling.
Yeah, I got problems with children under the age of 12 living out of a suitcase. I don't mind every other weekend, extended holidays, but when a child's in school, it's a little difficult. 8 years old, he can't be in the 2nd or 3rd grade. What grade is he in?
He's going to the 3rd.
Okay, where's he go to school?
He goes to Charles Drew.
Okay, Charles Drew. Okay, that's a good school. All right. Where do you live, Mr. Flint?
Snellville.
Okay, all right. And so I presume when you exercise your visitation that you come to Decatur or DeKalb County and pick up Destin and then go back and forth?
Yes.
Okay, all right. Are we paying any child support, or is that a separate matter?
Separate matter.
All right, then let me ask you this. Are you paying child support through the department?
Oh, no, sir. No, sir.
Okay. All right. So how are you supporting your child?
I pay for what needs to be paid for. I buy clothes and shoes. I give them.
Yeah, that doesn't cut it.
Me and Desiree just split up within the last year and a half.
Okay.
We were living together up until Destin was 7 years old.
Okay.
We just recently split.
Y'all come back now, you hear?
At some point in time, she's going to go see the child support office, because while that may have worked when you're living together, because, you know, we're sharing expenses, we're helping paying for the apartment or the house and car payments and insurance. But once you're separated, it's never, I won't say never, the court finds it difficult for a custodial parent to have to say to the non-custodial parent, hey, I need some money. Yeah, he needs shoes. He needs that gives the appearance of one having to beg. And I don't like for custodial parents, and I don't mean that in an ugly way. I have to ask the other side. That's what child support's for. I'm not going to order it. However, she's going to go to the child support office pretty soon if y'all can't reach an agreement regarding what the guidelines call for. So I'll grant the legitimation. It doesn't require a name change, does it?
No.
Okay. All right. And so I'm going to award just basic custody, but in the summertime, y'all need to split. All the national holidays, you need to split. And if y'all can agree on other stuff, such as if Destin and Miss Hunter, you're okay with his, Daddy having him Sunday night, get him to school on Monday morning, that's fine. But I don't want him being toting back and forth 1 week on and 1 week off, at least from Selbyville back to Charles Drew. That's just too much. So I can't do that. That's just not in my wheelhouse. Anything else I need to put in this order?
No, we do alternate the holidays already, and the summer he wants to do. I guess. Well, earlier I heard you say you do 2 weeks.
But if y'all want to agree, if y'all want to do it differently, it's because you certainly can tell me how you like. If y'all do it differently, what works for y'all? Because judges can mess up one-car funerals. So, what do y'all normally like to do for summertime?
Well, I normally enroll him in after-school program. I mean, but it's fine if I guess he get the 2 weeks, or we do month every other.
All right, Mr. Flint, what would you prefer?
I just want to be able to see my son.
I know that, but I'm asking you a specific question about summertime visitation. Would you like 2 weeks and then off 2 weeks and then having 2 more weeks? Or would you like him for the month of June and she has it for the month of July? How would you like?
I would prefer them the whole month.
Okay. All right. Miss Hunter, can you live with that? He gets him in June and you get him in July.
I guess that's fine.
Okay.
But July, he goes to school in July.
Right at the end of July, he comes back with you. So doesn't he start school about the 28th, the 27th? The
24th. He starts school the 24th.
Mess up a one-car
Okay,
funeral.
all right. When does he get out of school? Memorial Day?
Yeah, somewhere around there, like the 23rd or the 24th.
Okay.
Of May.
All right. Well, here's how I'm okay with that, because you'll get him till the end of May, and then Father will get him for the month of June, and you'll get him for the month of July. I'll put down, we'll split up the national holidays, and anything y'all can agree on outside of that, you're certainly welcome to. All right. We just need to have something in place, because the reality is this: y'all are no longer living together because something happened, can't get along, whatever. And I don't want that to bubble up over the relationship that y'all have with your son. And it just happened. Okay. So that's why I put this order together, that in the event that y'all have a falling out more so, then everybody's rights are protected up as far as Destin is concerned. Okay.
Okay.
Anything else, Mr. Flint, from you?
No.
Okay. All right. I'll get you.
Well, it's a few things. I want to be able to, how can I be involved as far as knowing my son, like medicals and being able to doctor's appointment, because I'm really shunned from everything.
Good question.
No, you as the legitimated father, you have the right. I'm going to put that in the order. Well, let me do this. Let me get y'all to both raise your right hand.
I can't hear you. I can't hear you. My phone.
I can.
What just happened? Okay. Hey.
Everybody raise your right hand. Do you swear affirm testimony about to give the matter opinion before the court shall be the truth, the whole truth, nothing but the truth, so be God?
Yes.
Okay. Yes. Everything y'all have told me is true and correct, right?
Yes.
Yes.
Now here's the deal. In this order, Mr. Flint, you will have the right to all his medical records. You'll have the right to go to school and look at school records. All right, because you're his father. So he can't prevent you from any of that. She will have
Donald,
to let you know.
Congratulations and thank
where he
you.
goes to the doctor.
Thank you,
I'm sure you probably already know. And where he goes to school. But if you don't, she has to keep you informed. The custodial
I
parent has to
don't.
keep the
I wish it would just
non-custodial
a little
parent
bit, but no.
informed of where they go to school, where they go to doctor. There's a change of address. And with this order, as the legitimated father, you have the right to go to the school, to meet with his teachers. But I need to tell you something. Since several family members of mine are school teachers or were school teachers, if there's a parent-teacher conference, you don't need to make the teacher meet y'all separate. Y'all need to be in the same room so you can hear the teacher one time, all right? But you'll have that right as a father. You've been the father, but as a legitimated father, you have that right. So, and I'm sure that Ms. Hunter's going to cooperate. She won't have any problem doing that. Just give you the notice, all right? Remember, I'm optimistic, all right? Y'all have done a good job, apparently, with Destiny. You know, sometimes I got parents come in here and say, don't make me pick up my child. You know, y'all, you don't have that problem. Y'all both want Destiny with you. He's doing well in school. He's at a great school. So y'all are going to do fine. You'll get the order, and you can do those things. You can, you know, but don't wear everybody out. Somebody makes a B on a paper, it's just a one-time deal, all right? I'm still working on my spelling from the 3rd grade. I didn't do very well then, so really, just let Destin have a good time. He's only going to be 8 once, all right? So if y'all got to disagree, you make sure it's done away from him.
Thank you so much. Thank you.
All he needs to know is his parents love him and excited to see him and that kind of thing. But that doesn't mean he can eat ice cream at 9 o'clock and not brush his teeth and then drive your car, all right? Or your car. It doesn't mean that. All right. Y'all know what you got to do. I'll get you an order. Anything else either one of y'all want to share with me?
No.
Okay. I wish you the best of luck. I'll get y'all an order. Congratulations to both of y'all. All right. Thank you.
Right.
Damn, that's it. That's all the clips I have. I know that hold on, I'm just gonna look one more time because Spades sent me a link and I recorded it. I was sitting right here. I was here when I did it. It was right after I got off work. It was Reagan. But I don't have it, so I can't play it because it's not there. I hope I can get more of that judge. I hope that he's covering like a vacation, like 2 weeks. Yeah, I just lifted my words at the end, and I know that legal fiction hates that. But he's not here, so I can do it all I want. Beautifully inappropriate. Hello. Should I get it now, Fozzie? Should I just open up the link that Deborah put in Discord and just play it right now? Oh, man. I'm like begging to get demonetized if I do that. I'm doing it. I'm doing it, guys. Let's just see what it is. I mean, I can just hit that red X. I'm sure it's fine. I'm sure it's all good. What is this? Like, it's not murder, is it? Oh, no. Oh, sovereign citizen? Let's go. Let's go. Thank you, Deborah. Hold on, I'm getting there. Oh, I was just watching him today. How I missed this? Anyway, I gotta unmute everything and bring it over.
Access
to this hearing, both in the courtroom and also online. And our first case this morning is People v. Trevor McLeod, file 23-6748FH. Counsel, you want to state your appearance, please? All right, Mr. McLeod, do you still desire to represent yourself, sir?
Yep.
All right, and I'm required to remind you at each hearing that you do have the right to be represented by an attorney, including an attorney at public expense if you qualify and request. And do you wish to have an opportunity to hire an attorney or to seek appointed attorney or no?
I don't want to make that decision right now.
Okay, so you're continuing to represent yourself. That's correct. All right, and you understand that you have those rights. Okay. All right, well, we're here for a docket call that I had scheduled because Mr. McLeod had requested a jury trial, and I wanted to touch base and have you both submit proposed jury instructions.
Was this like 2 months ago? I think I remember this, but it was like, was this like a month ago or 2 months ago? But I thought I saw him. I only see the judge in this clip. I thought I saw him standing and the judge, but it sounds just like the one I saw.
Which I did receive, thank you both. So what I want to do is I'm going to have ask the bailiffs to deliver to you 2 packets. One is the ones that begin with 2.1. Those are the preliminary, it's for defense. The preliminary jury instructions, and then the 3.1, or the ones that start 3 point. Those are the final jury instructions that I would propose to give, so those will be for your review. And I want to discuss a couple things about that. The count 1, the defendant is charged with contravention, resisting, obstructing. That's a bit of a strange statute. There's no model jury instruction for that charge precisely. The prosecutor based it on 13.2, which I think is correct, although I did amend the prosecutor's requested charge to add some language from 13.1 that is also a correct statement of the law, particularly the statement that the defendant must have actually resisted by what he said or did, but physical violence is not necessary. And then also, because Mr. McLeod, you've raised a lot of legal challenges in this case that I had denied. Typically, challenges on the law are for the court to decide and not the jury. And you wouldn't be able to present those arguments to the jury. However, because you're charged with resisting and obstructing the conservation officer, the lawfulness of the officer's actions is indeed an element of the offense. So I am required by law to instruct the jury on the framework that they need to decide that. So I've included some language for that the prosecutor did not request. So I want to read my...
Oh, he's getting into the university that he wanted to, right? Wow. Oh, man. Charlotte, you're such a good mom. You really are. I know that was hard for you to get him to cross that finish line. I had to drag my son. Good job. Good job. That's awesome. We were worried yesterday, but today, man, this is great. Grandpa's home. Son passed his exam. It's awesome.
Instruction on count 1 that I'm going to be reading at the trial. And then that, in count 1, the defendant is charged with the crime of assaulting, battering, wounding, resisting, obstructing, opposing, or endangering a conservation officer who was acting in the performance of his duties. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted, battered, wounded, resisted, obstructed, opposed, or endangered Dan Listenfeldt, who was a conservation officer performing his duties. Obstruct includes the use or threatened use of physical interference or force, or a knowing failure to comply with a lawful command. The defendant must have actually resisted by what he said or did, but physical violence is not necessary. Second, that the defendant knew or had reason to know that Dan Listenfeldt was then a conservation officer performing his duties at the time. Third, that Dan Listenfeldt gave the defendant a lawful command, was making a lawful arrest, or was otherwise performing a lawful act. A conservation officer may make an investigatory stop of a vessel if that officer has, based on objective facts, a reasonable and articulable suspicion of a violation of law. A conservation officer may make an arrest without a warrant if that officer has probable cause to believe that the defendant has committed a crime. Probable cause exists where the facts and circumstances within an officer's knowledge and of which he has reasonably trustworthy information are sufficient in themselves to warrant a person of reasonable caution in the belief that an offense has been or is being committed. Defendant is a member of a Native American tribe that is a party to a federal court consent decree that binds the state of Michigan and its law enforcement officers. Under the terms of that consent decree, tribal members operating boats or other vessels who are engaged in the exercise of a treaty-related hunting, trapping, fishing, or gathering activity shall not be subject to state vessel registration requirements, provided that the tribal member satisfies tribal license requirements for the activity in question, is in compliance with the applicable tribal hunting, trapping, or fishing season limitations and tribal law adopted pursuant to the decree, and possesses evidence of being currently engaged in hunting, trapping, fishing, or gathering, such as fish, game, or common items related to hunting, trapping, fishing, or gathering, such as fishing rods, tip-ups, firearms, traps, or nets. Fourth, that the defendant's actions were intended by the defendant, that is not accidental. So in instructing the jury on the framework for which they should consider whether the officer's actions were lawful, I'm including in that instruction black letter law on reasonable suspicion and probable cause for a stop and rest, and I've included the direct quote from the consent decree that I believe is the provision that you've been arguing, Mr. Mr. Juliet, do the people have any objection to that instruction?
No, Your Honor.
Mr. McLeod, do you have any objections to that instruction to the jury for the trial? And then in count two, the is the operating a motorboat while intoxicated. My model instruction is not that it was requested by the prosecutor. I model it on the OWI.
Before we get into Sob Sick Crazy, which I can't wait to get to, and I hope it's really good. I haven't seen this, so I don't know. It could be good, it could be bad. I just want to stop and thank you to my mods because they do so much work, even behind the scenes, like a lot behind the scenes. And they're in hurricanes today and they're here. You don't got to do that. Some of them live in houses where the toilet flushes backwards and they're here. It doesn't even bother them. They're here helping everybody out. But I really, really am thankful for all of you. You guys are so great here. And you guys talk to everybody, and you guys are really, really great. Thank you. Now the subset.
Vehicle as to the prosecutor. However, the charging document in this case, the information, there's two ways to charge someone with operating while intoxicated. One is an under the influence theory, and one is a over the limit theory. The information in this case did not include the over the limit theory. It included only the under the influence theory. So my instruction only includes that. So the instructions the prosecutor proposed for the, being over the 0.08 limit, that's not what's been charged. I'm not getting that. So the instruction would be as follows. In count two, the defendant is charged with the crime of operating a motorboat while under the influence of alcohol. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant operated a motorboat. To operate means drive or have actual physical control of the motorboat. Second, that the defendant operated a motorboat on the waters of the state. Third, that the defendant was intoxicated. That is, the defendant operated the motorboat under the influence of alcohol. Under the influence of alcohol means that because of drinking alcohol, the defendant's ability to operate a motorboat in a normal manner was substantially lessened. To be under the influence, a person does not have to be falling down or hardly able to stand up. On the other hand, just because a person who has drunk alcohol or smells of alcohol does not prove by itself that the person is under the influence of alcohol. The test is whether, because of drinking alcohol, the defendant's mental or physical condition was significantly affected and the defendant was no longer able to operate a motorboat in a normal manner. Mr. Juliet, do the people have any objection to that instruction?
No, you're out.
Mr. McCall, do you have any objection to that?
I'd like to include visibly impaired in that life law, so it's.
You'd like to include visibly impaired as a lesser included offense?
No, I'd like the language to include that, like the law states that I have to be visibly impaired while operating.
Well, visibly impaired, operating while visibly impaired is a lesser offense than operating while intoxicated.
But the statute under the conservation, section 8 says this indicates to a vessel that is being operated while visibly impaired. It's written, which is the charge.
Right. But the that statute.
It's number 8. Or number 5, I think.
At least we get to see him for a second here.
Yeah, subsection 3, a person shall not operate a motorboat on the waters of the state when due to the consumption of alcoholic liquor or a controlled substance or both, the person's ability to operate is visibly impaired.
Ability to operate is very correct. Right. And then I'd like to include number 8 in that same.
Oh, the definition of operate as used in this section, operate means to be in control of a vessel propelled wholly or in part by machinery while the vessel is underway and is not docked at anchor, idle, or otherwise secured.
Right.
All right. I will include the definition of operate under subsection 8 under the second element where it says second that the defendant operated a motorboat in the waters of the state. Operate means, and then I'll give the statutory instruction. But Mr. McLeod, the operating while visibly impaired is a lesser offense. So I can instruct the jury if you request, and I can change the verdict form to this effect too. It says that they can consider whether you're guilty of the operating while intoxicated, or they can consider the lesser offense of operating while visibly impaired. The operating while intoxicated is a higher burden to prove. The language under the influence of alcohol legally is a higher burden than the visibly impaired. So sometimes defendants want the lesser included as an option. Other times they don't because they don't think that the higher burden would be met. But so what I would not do, I would deny your request to like combine them into one instruction. But if you want the visibly impaired given, that's a lesser offense. And I'll let you think on that. We're going to come back for another doctor call in July. If you request a lesser included, we'll do that. I'll make a note, possible lesser included impaired. All right. A couple other things. For jury selection with Mr. McLeod representing himself, I think the law does allow the court to conduct a voir dire, and I'm going to go ahead and do that. So I'm signing an order today that on my own motion, I will examine the prospective jurors during jury selection and not allow direct questioning from either the prosecution or the defense.
I object to that.
Noted and overruled. But I'm giving both sides, as required by the court rules, an opportunity to submit written questions. So you have to submit written questions to me.
I would love a subset friend. Oh my gosh, I would have a blast everywhere we went. I would have a blast. Everybody, I would get kicked out of everywhere, but I would have so much fun. And then I would post it.
Not later than Tuesday, July 2nd, so I can review them. And we're going to come back for a docket call on July 9th at 9:30 a.m. And then I will not ask questions that I determine are improper, irrelevant, or unnecessary.
So I'm sorry, you have a jury of my Native Americans, my peers.
No, sir. It's a jury selected at random from folks in the county. All right, and also, Mr. McLeod, you've waived your right to counsel, and we've gone through the waiver process, and I believe that you have knowingly, voluntarily, and understandingly waived the right to counsel with your eyes open as to the risks of self-representation, that you're choosing to exercise your constitutional right for self-representation. That, of course, doesn't allow you to become disruptive to the court processes. You've not been doing that of late, but
Legal's here. Don't tell them what I did earlier.
there was some history early on of that. So under Supreme Court precedent for Florida v. California in 1975, this court may, even over objection, appoint what's called standby or advisory counsel to aid you if and when you ask for help, or to be available to represent you in the event that the termination of your self-representation is necessary. So therefore, on my own motion, I'm appointing the Sheboygan Office of Assigned Counsel, not to act as your attorney, Mr. McLeod, but to act as what's called a standby or advisory counsel. So they'll be present at the hearing in July and at the trial. That they won't participate. They'll be there to give you advice if you have any. If you don't have any, they won't give it. And then if, for example, you became disruptive during the trial to the extent that even despite warnings, you persisted and had to be removed, then the attorney would jump in and finish the trial on your behalf. But as long as you're not disruptive, that's not going to be an issue. But they're there just as advisory counsel for you. All right, Mr. Juliet, any objection to that?
No.
Mr. McLeod, do you have an objection to that?
I object. I want to represent myself.
And I'm going to let you represent yourself, but I am going to appoint a standby or advisory counsel just to assist you if you deem necessary. And then I did notice as I reviewed the witness and exhibit lists that were submitted by both parties, Mr. McLeod, you had listed both magistrates in the district court, district court judge,
I raised my
probate court judge,
at the end of each.
the elected prosecutor, and a retired circuit judge. Can you tell me what
It's all pertinent to that situation.
In what respect, what testimony do you think that they'd be offering would be relevant at the trial?
Do I have to tell them to say all that?
Yeah, you got to tell me that it's relevant, because I don't see how that's possibly relevant.
Well, the magistrate and the prosecuting attorney went ahead and prosecuted this case without having a warrant on file. The judges all looked through this file, didn't have a warrant on file, so pursued it. So I mean, it's kind of like your job, isn't it, to make sure all the paperwork's in order?
Sure, but that's not relevant to what the jury has to do. What the jury has to decide is whether the officer's actions on that day were lawful, and whether you were resisting him and or operating a motorboat while intoxicated.
Not guilty if he is guilty of a charge.
One more outburst, and you'll have to leave. So the judge's testimony, magistrates and prosecutors, not admissible or relevant. So I'm going to strike from your witness list Magistrate Ellenboss, Magistrate Libby, retired Judge Spartan, Judge Vizina, Prosecutor Goodrich, and retired Judge Pavlich. So you may not call those folks as witnesses. And what we'll do then is come back for, you both have until July 2nd to come back for, or you both have until July 2nd to file witness and exhibit lists, or I'm sorry, to file requested questions that I would ask the jury during jury selection to achieve a fair and impartial jury.
We're not going to get a fair and impartial jury because they're not going to be Native Americans. It's the whole situation.
Well, that doesn't, if somebody's African American, we don't seat an entirely African American jury. If somebody's Asian American, we don't seat an entirely Asian American
It's not
jury.
true, not yours.
It's not, well, sure.
The argument that I'm fighting is based on the treaty rights. That's the whole thing about it.
Yeah, in fact, it would violate the Constitution if I tried to seat a jury of only Native Americans and excluded people based on their race. So I would decline your invitation to engage in racial discrimination in jury selection. So So you have until July 2nd to submit written questions. And we'll come back for a hearing on July 9th at 9:30, so I can tell you which of those questions I'm asking or not asking. I'm granting Mr. McLeod's request to add the definition of operating, and we'll give him until the 9th to decide if he wants the lesser included or impaired instructed.
Is that the 9th or the 2nd?
The 9th, yeah. The 9th is the hearing. And we are still scheduled for jury selection August 8 and 9. All right, anything further for today from the people?
Just briefly, Your Honor, while we're on the record, Mr. McLeod and I have been undergoing continued plea discussions. I guess I would just ask the court its position on a few possibilities for resolution.
Okay.
I know in the past with some cases we've done plea to a felony with a very short term of a delay with a dismissal at the end. Is this the type of case the court might consider something like that?
Yeah, I mean, from what I've learned about the case in the pretrial motions, although your legal arguments have been unavailing, Mr. McLeod, I don't think your underlying conduct in this case was all that egregious. And so, I mean, I'm not looking to lock you up, even if you're convicted after the trial. So whatever negotiated outcome you guys could come up with, I would have no problem. I don't think your behavior was extreme.
Can I motion for summary judgment?
What's that?
Can I motion for summary judgment?
Well, no, I mean, you already did. There has to be like a legal grounds to dismiss, which I've denied, or that there's not enough evidence of probable cause to go forward, which I've denied. There is probable cause to go forward to the jury. So I can't decide instead of the jury. I mean, you could waive your right to a jury and have a trial in front of me, but both sides would have to agree to that. Or if you wanted to enter a plea of guilty or no contest, the charges or some lesser charges as the prosecutor and you sort out, you can do that as well.
Well, right now what he's proposing is a disturbing the peace with no probation, no jail, a week delayed sentence. I would like to add to it. No fines, no cost, because I already paid to drug testing and all that stuff for the first 12 months. And I'd like to also add to it that the delayed time served because of the time spent on drug testing.
Not going to try.
All right, well, and if you guys come up with a negotiated outcome, then there are things that you both can agree to, and then there's things that you can leave if you're not agreeing to them, that you both can argue to me, and then I can decide, Well,
that's where we're at right now. Let's do it right now.
All right, so I think what we'll do then, just because I haven't scheduled anything else on the August trial date. Sometimes I schedule backups, but I haven't done that in this case. And because I want to preserve the ability to use those dates or something else, I'll indicate that the July 9th hearing will be a plea cutoff as well. So if there is any kind of
well, I guess what I'm wondering is if I take this plea and something.
Well, I haven't heard clearly what the plea would be.
Well, I guess he's accurate that I did offer a disturbing the peace, but I know this court doesn't do misdemeanor probation, so I think it would have to be a plea to the 2-year on a week delay with a dismissal at the end. It's technically felony probation. I'm willing to give him a disturbing the peace, but again, I don't think this court would.
Wait, you want to do a disturbing the peace with a delay and dismissal?
No, well, I'm fine with that, but I don't think this court will do a misdemeanor probation.
I would do a misdemeanor delay with a dismissal if it's a short delay, and I wouldn't have Department of Corrections supervise them. I would just supervise it internally with court staff.
Okay, I will get that drawn up then.
If you reach an agreement and you want to come in before July 9th just to get it done, just contact court staff and we'll schedule a time for you. Any other questions, Mr. Julian? No. Mr. McLeod? Okay. All right, we'll be in recess.
All right.
We are on the record in the
Wow, guys, that was awesome. Judge kept him in line, unfortunately. You know what? If we don't get to see him and do the trial, though, that's going to be like heartbreaking. I was ready. I was ready for the trial of the century. That's all right, though. Maybe this judge on the screen will be on today and make everybody feel better. Maybe this judge did make us forget about that awful hurricane for just a few minutes. But now we have to remember there's a hurricane right on top of us. Good night, Queen. Good night. All right, that's all the clips I have for today. I don't have any more. I just don't. I need the people from Texas to stay safe. Do not go outside to get a video of the car flying down the street. We don't need the video. We don't need to see it. Nobody wants to see it. We want you to stay safe. No. No, Donald. Nope. Because my eyes are about to close, which I love doing. I'm so good in bed. I can sleep all day long. Yes, I can. Justin's sweatshirt. Just do it. Oh man, I'm gonna try to make shorts of all of his little sayings that he had in there, especially about the judges messing up a one-car funeral and all those. Oh, it was so good. See, everybody's worried about you, Texas peeps. So yes, I can sleep all day long. Yes, I can. All day. I can snore like the best of them. Everybody's going to be watching the Weather Channel today. Nah, it's too much work to make one little clip like that. No, legal. I said no. They're not in Florida. Yeah, see, that's what Florida man would do. They don't live in Florida. They're Texans. See, you have to do what Deborah says. Stay safe. You have to do what Miss Glow says because nobody makes Miss Glow mad around me. Nobody. She says stay safe. You stay safe. All right. Yes, Guinness is a good idea. Fozzie, thank you. Donald, thank you. Kelly, thank you. Charlotte, I'm so proud of your son. Go buy him an Xbox. Just kidding. He can buy his own now. And he graduated high school. He can get a job. He can work and get it and go to university. Don't worry, he can. Oh, Deborah, man, you're a mess. Your family is all in the hot spots. See, everybody should live in Pennsylvania. We don't have none of that. We just have blizzards. They're easy. See? See? Chris don't want to make nobody mad. I agree with that one. I know, Chris. I know. We waited for you to come in, though, before we had to say goodbye. I hope you're doing well, Chris. I don't know. You know what? That sure is a question, guys. What if you live on the Florida-Texas border? You would be very special. You would be. My mama's so. Never mind. All right. Good night, guys. Good night. I will talk to you soon. If you can, post updates in Discord if you're okay. If you can't, don't worry about it. Yeah, I'm going to Discord security. I'm going to Discord right now. How is my Discord dinging? It's legitimately not even open in the system. Oh, I opened it on the website. Never mind. I had to get that link. I'm going to Discord, so if anybody wants to talk to me, go into Discord. Other than that, be safe. Bye. Thank you for coming out, guys. I appreciate it. Thank you. Bye.